Hello, everybody, and welcome back to another episode of SEC Roundup. My name is Nick Morgan. I'm a partner in the Investigations and White Collar Defense Group at Paul Hastings. With me, as always, is my partner, Tom Zuccaro. Tom, how are you doing?
I'm doing well, Nick. Good morning.
And we are pleased to be joined by Lisa Gock, who is the Chief Legal Officer at Cetera and a former Assistant Director in the SEC's Enforcement Division. Lisa, good morning. Thanks so much for joining us.
Good morning, Nick and Tom. Happy to join.
Hey, Lisa.
So we're going to talk about a topic that has had sort of a low boil that has recently come to sort of fruition. This is Reg BI. So for those of you who haven't been following this, this is a long-standing debate about whether or not the fiduciary standard that applies to investment advisors should also apply to brokers. There was a debate about it years ago. The Department of Labor passed a rule that would have applied to some accounts. The court struck down that rule. Then the SEC implemented Reg BI, Regulation Best Interest. And now, most recently, last month, the Enforcement Division brought its very first ever case involving Reg BI. Tom, can you tell us a little bit about that case?
Sure, absolutely. So, Nick, as you just mentioned a moment ago, this is the first Reg BI case brought since the rule was adopted 2 years ago. It was brought here in Southern California, Los Angeles Federal Court. The SEC sued a registered broker-dealer and 5 of its registered reps for violating Reg BI. The facts are relatively basic. The reps sold what were described as L bonds to its investors. The L bonds it sold were unrated, illiquid, and deemed to be high risk. The clients to whom the bonds were sold were mostly retirees and other retail investors for whom the SEC believed the sales were not suitable. On top of that, the SEC charged both the broker-dealer and the reps with failing to be informed concerning the nature of the issuer's business, as well as the nature of the bonds, and of course the typical compliance issues that normally are charged in this type of case. The case is being litigated; it's not settled, and it's, as I said, it's filed here in federal court in Los Angeles.
Thanks for that summary, Tom. It doesn't sound to me like the facts were all that different from a case that might have been brought 5 years ago, but I'm sure, because we all like to try and read the tea leaves and figure out where the SEC is going, there are lessons to be learned from this case. Lisa, as you read this case, what should we take away from it? What's the important lesson to be learned from Reg BI and the SEC's view on it?
Sure, Nick. Well, given that it's the first case the SEC is bringing under Reg BI, it's a little bit hard to predict what will be happening. But I will say, just because you hear about these things in my industry, I think there are other similar type investigations going on. And what I would call this is a suitability due diligence product failure case, which we've had those, forever. And the case could have easily been brought, for example, by FINRA under the suitability rule. In fact, I believe the complaint use the word suitability, but it all goes to Reg BI. So a little hard to tell, but as you may recall, when Reg BI first was enacted, there was some criticism by consumer advocate type organizations that it didn't go far enough. So by bringing enforcement actions, this could, demonstrate that the SEC really intends to enforce Reg BI, however they define it, and it will be continued to be defined, I think, as the cases go on, and maybe those groups will feel better about Reg BI. Specifically from the case, again, it's a due diligence type product failure case. A couple of takeaways that I'd say specifically from the case are, one, the SEC has named individual registered reps in the case Not that usual. And in, I think one case, one of the registered reps made about a little over 5,000 in commission. That's somewhat, that's small. And so indicates, well, just that the SEC is going to be very vigilant in this area. Aside from that, there's, for a takeaway, perhaps for other firms, is in diligence. The complaint states that the product changed over time, but there was no new training done of the reps. Obviously, you want to keep up with your due diligence and do training. And then I guess the other takeaway, let's see, I think I have one more. Oh, they talk about reasonably available alternatives, and that, and they went to the firm appeared to just copy some of the some of what the SEC had said in its releases, as opposed to tailoring the procedures to their firm. So these are kind of easy lessons for firms to know about. So assuming these facts in the complaint or these stated facts are true, there appear to be, you know, some failures there. So.
Yeah, interesting. Well, I'm sure everyone will study this case. And as Tom said, it's a litigated matter. So who knows what will happen in federal court? Maybe the broker dealer will make new law and we'll all learn something from that. But I really appreciate your insights, Lisa. Thank you for joining us.
Thank you, Lisa.
Thank you.
And
Yeah,
thank you, everyone. Please tune in for our next episode of SEC Roundup. Bye for now.
Bye-bye.